Okay, it's 12 o'clock, so let's get started. Hello, my name is Marjorie Greek, and I am the owner of Pearl Fiduciary Services and the co-chair this year of Boulder County Senior Law Day 2021. So welcome everyone to today's seminar. This is our second year doing virtual webinars. Usually we're in person, and hopefully next year we will be back that way, but right now it's virtual. And I guess one of the advantages to that is that we can record these sessions. So we are being recorded right now, so you're aware of that. And we'll have the video available in a couple of weeks. We'll send out an email to our registered attendees and let them know when they're available and give you a link as how to access them. So you've entered this webinar in muted mode. Please remain on mute unless the speaker invites you to unmute yourself. And we will be taking questions during the webinar. The easiest way to get those questions to us are to enter them into the Q&A or the chat box. You can find that in your menu bar on Zoom. And if you don't see that on your screen, you might need to just activate your screen by moving your mouse or touching the screen or the keyboard. And then you should see the menu bar at the bottom of the page. We'll probably take questions as we go today, so feel free to just type them in when they pop up for you. This is getting close to the end of our webinar series. We have 3, including today, left on our agenda. And of course, all of these webinars are from noon until 1. Next Tuesday and Thursday are our last 2, but if you'd like to sign up for those, you can always go to our website at bocoseniorlawday.org or bouldercountyseniorlawday.org and sign up for those, or get that information to your friends or colleagues and get them to register and participate as well. And I will be putting this link information into the chat box after I'm done with this portion of the presentation. The Boulder County Bar Association hosts a free legal clinic as well. They're one of our platinum level sponsors, and we want to thank them for that. But you can contact them by phone and get paired up with an attorney for a brief legal consult on a very large variety of topics. Their number there is 303-440-4758, or you can apply online at www.boulder-bar.org. And again, we'll put that information into the chat box for you so you've got that available. Senior Law Day handbooks are also available online. You can either go to seniorlawhandbook.org or hold your camera on your cell phone up to this QR code. And if I move my little speaker thing here, you'll be able to see that barcode, and you can use that to link you to get the handbook. And we want to thank our sponsors. Our platinum sponsors are the Boulder County Bar Association, Pearl Fiduciary Services, and Fraser. The gold sponsor this year is Jorgensen, Brownell, and Pepin. Silver sponsors are Hofgaard Law and BOK Financial. And then the bronze sponsors, Kingsbury, Johnson & Love, and Friends of Longmont Senior Services. I also want to make sure to thank our planning committee this year. They're the ones who've really made this year's Senior Law Day possible. And they include Pete Rogers, Brett Landis, Erica Corson, Maya Labrie, Allison Oates, Susan Spalding, and Diedre Braverman, who is going to be our speaker today, our presenter. So Diedre has been an estate and special needs attorney planning attorney for over 20 years. She is a Stanford Law graduate, married with 2 adult children. Her first special needs trust was for her brother Nathan, who has severe autism. Diedre co-founded the largest national organization for special needs planning attorneys, the Academy of Special Needs Planners. She also co-authored a 2-volume treatise for attorneys on special needs planning. Most important, Diedre practices with a passion for improving the lives of the disabled, the mentally ill, and other vulnerable people. Diedre, thank you so much for joining us today. Thank you for what you've done for Senior Law Day. And we're really looking forward to your presentation.
Thank you, Margie. Great. Okay, I'm going to put the presentation up. Does that look good, Margie?
I'm not seeing it yet.
You're not seeing it.
Did you do a screen share?
Oh, whoops, maybe I didn't. Oh, I need to. Sorry, folks, I am actually a very experienced Zoom user. Okay.
Finding those little icons when you need them.
Let me see if this works.
There you go.
Do you see the one page?
Yep.
Okay, great.
Looks just great.
Okay. So welcome, everyone. Please feel free to ask questions in the chat box as we go. Margie will interrupt me and bring them into the presentation. And I'd love to have this be conversational. We're going to structure this as special needs planning mistakes to avoid. But we're going to cover all the content you would need in an introductory special needs planning presentation. So mistake number 1 is dying with no will or trust. That's called intestate. And what happens is you're assuming your beneficiary, the person with special needs, is your child. They lose eligibility for SSI and Medicaid because they have inherited more than $2,000 from you. Your estate goes through a process called probate, which is more expensive and time-consuming and public than if you created a revocable living trust for your estate. And you may end up paying estate tax. Right now, the estate tax exemption is a hefty 11.6 million. But in 2026, it will drop down to 6 million. That's already in the law. And there is talk of lowering it to 3.5 million before then. So the estate tax won't affect most folks, but if it does affect you, you want to plan for it because the tax rate is 40%. It's confiscatory. And if money goes to grandchildren, you could even end up paying close to an 80% tax rate. Okay, so the summary of this page is it's a good idea, it's a will, and if you own your own house, you probably want a revocable living trust. Mistake number 2 is disinheriting your child in that will or trust. Your child, the benefit is your child will continue to receive their SSI and Medicaid, but they will get no benefit from all the hard work you've done over your lifetime. They'll have to live a public benefit standard of living, which is pretty darn tight. SSI, $700 to $900 a month. You can get some Section 8 housing and get your health care paid for, and that's about it. Maybe able to get some food stamps. So disinheriting your child is a solution people used before there were special needs trusts. Mistake number 3 is ignoring your child's special needs when creating their trust. There are lots of different kinds of trusts you can create for your children or other beneficiaries. there are asset protection trusts, there are management trusts, but a special needs trust is a different kind of trust, and only a well-drafted special needs trust will preserve your child's eligibility for needs-based government benefits. So if you go to an attorney who doesn't have experience in drafting these trusts, you may get a trust that says special needs trust, but it's not actually a special needs trust. It doesn't actually comply with all the laws that it needs to for your child to continue to receive government benefits. So you don't want to create just any trust for a child with special needs. Mistake number 4 is creating a generic special needs trust. This is still a big improvement over all of the other mistakes. If you create a generic special needs trust, you're doing a pretty good job. And by the way, I just want to acknowledge everyone here for not only caring about a person with special needs, because I know it's difficult to care about someone with a developmental disability or a mental illness. It's difficult because they don't act the way everyone else acts and they need special care. But not only do you care about that person, you're actually taking action to help them because you're here at this seminar learning about special needs trusts. And I just want to commend you for the time you're putting in to caring for the child in your life. Great job. Great job. Okay, so creating a generic special needs trust is the least bad of these mistakes we've covered so far, but it's nicer for them if you can provide some guidelines about the care that child needs. You can put the guidelines into the special needs trust if they're not going to change. Like our child is paraplegic, but likes to go to sporting events. That's probably not going to change. You can put that in the trust. Then there's a memorandum of intent, which is your letter to the trustee. And there you would put information like, my autistic daughter will only eat goldfish crackers and steak. That's not a permanent situation, we hope. So you might put that in your memorandum of intent to let the trustee know that that's what they need to do to keep her from being malnourished. And the memorandum of intent is easy to change. A special needs trust can be irrevocable, which means you can't change it, depending on your goals. So the memorandum of intent gives you a nice way to keep it up to date, despite its being unchangeable. Mistake number 5 is procrastinating. This is the biggest mistake and the most dangerous. The trust you can create for your child is unique. It's not a trust they can create for themselves. You may have heard that beneficiaries can put their own money into special needs trusts, but those are very different kinds of special needs trusts. There are basically 2 kinds of special needs trusts. There's the kind we've been talking about, which we call a third-party special needs trust, because a third party is creating and putting their money into that trust. And that's the kind of trust we create when we do estate planning, or we plan with the parents or an aunt or uncle or grandparents. We create a third-party special needs trust. But there is another kind of special needs trust. It's called a first-party special needs trust. And there are other names for it, like a D4A trust. So don't get hung up on the names, but a first-party special needs trust can receive a beneficiary's inheritance even if it's not in a special needs trust. So let's say you procrastinated and your beneficiary got an inheritance. They could create a trust. In Colorado, it would take the court, a parent, or a grandparent to create this trust. So if their parents and grandparents are deceased, they would need a court order to create this first party kind of special needs trust. Now, because it's their own money, they would not traditionally have been allowed to create a special needs trust, but Congress acted and created a federal special needs kind of trust. D4A is the code section, the end of the code section. If anybody actually wants to look it up, it's 42 USC 1396 D4A. And that federal trust allows a beneficiary to put their own money into a trust, but more restrictive rules apply. The two big ones are that the trust is supervised by the Colorado Department of Healthcare Policy and Financing. That's Colorado's Medicaid agency. I shouldn't say supervised, I should say approved. It may be supervised by the court, depending on what the court orders, and that could involve annual accountings and filings to the court. And any money left in the trust when the beneficiary dies goes to the state, not to their children or your other children or your brothers or sisters, whoever you've chosen. It goes to the state of Colorado. So that's a real downside of creating a first party special needs trust. The other downside of procrastinating and forcing them to do this is that they have to have good advisors around them who understand this and will create this first party special needs trust for them. A lot of times it doesn't get created, and what happens is the beneficiary spends their inheritance, they lose their SSI, they lose their Medicaid, they spend their inheritance on their medical needs and their living expenses. Then they have no inheritance left and they go back on SSI and Medicaid, and it's as if they never received an inheritance in the first place. So I strongly encourage you not to procrastinate and to get into a qualified attorney to create a third-party special needs trust for your beneficiary. When you have created a third-party special needs trust, you can invite contributions from other people. If you're a parent, maybe ask their grandparents if they're leaving any money to the child. And if they are, make sure the money doesn't go to the child in their own name, but goes to them through their special needs trust. So the beneficiary on grandma and grandpa's estate planning documents needs to be the special needs trust. And most attorneys will create a letter or a certificate that will tell grandma and grandpa's attorney exactly how to do that, how to name the trust as a beneficiary. And if you are able to get multiple people contributing to the trust, you may be able to get a much longer benefit for your child, less likely to run out of money. Which I should mention, you want to work with an attorney who can calculate the amount of money your child is going to need in that special needs trust. If you only have a few $100,000, there's no need for a calculation. You'll leave everything you can to your child and we'll hope that the trustee can make it last. But if you have a more substantial estate that might be more than what your child needs for life, we can run calculations on what their benefits are, what their needs are, what you're contributing to them, what a reasonable rate of return on their trust assets is, and determine just how much needs to go into that trust so that you don't overfund it. more likely the problem is underfunding it. Mistake number 7 is choosing the wrong trustee. And this is a tough one for people because I know they want to ask a family member to be the trustee of the special needs trust. But a family member may make sense in a different kind of role because the special needs trust can incorporate lots of different people into its management. Let me tell you what the trustee does. The trustee invests the money, so they're responsible for getting a reasonable rate of return without excessive risk on the money. They make the distributions, so they're the final say about how the money is spent for your child. That's tremendous power. They may be responsible for reporting to Medicaid or Social Security, depending on how that is arranged. They may be the representative payee. They're responsible for keeping track of everything that comes into the trust and everything that goes out of the trust and preparing an annual report, which they will present to the beneficiaries who are set to inherit after your child. We can also have them present that annual report to other people, like siblings, aunts and uncles, or a trust protector.
Hey, Diedre, this is Margie.
Yes.
What's the difference between a trustee and a guardian, and how do those two roles maybe work together or separately within a trust?
I love that question, and it's the perfect time because we're talking about different roles. So the trustee manages the special needs trust, mostly from a financial perspective, although they do make the decisions about how the money is spent. A guardian and a conservator, those are two other roles that may be involved. Those are court-appointed roles. So the trustee is named by you in the trust, and it's a private matter. The court isn't involved at all unless something goes wrong. But a guardian is a court-appointed care provider for your child's personal and health decisions. So the guardian decides where they will live, make sure they're getting enough nutrition, hires their doctors, therapists, caregivers, and reports to the court once a year or more often, depending on the situation. So a guardian is typically paid. If they're a professional guardian, like Margie does with her Pearl fiduciary, they have a published fee schedule. If they're a private guardian, like a sibling, they can be paid something similar to what they make at work. Or if they have a specialty, like they're a nurse or something, maybe something more. And then a conservator is a court-appointed decision maker about the finances. So if you have a special needs trust, it's likely a conservator won't be needed. The conservator will only be needed if there is money outside of the special needs trust and outside of Social Security benefits that needs to be managed or distributed. And the conservator is appointed by the court, paid hourly, and reports to the court at least once a year. So a guardian is not uncommon. A trustee is, of course, necessary if you've created a special needs trust, and a conservator you can probably avoid. So within the trust, what are the roles? There's the trustee. We've talked about how they have responsibility for investing the money and spending the money and reporting what happens with the trust. Then you can name other people. You don't have to. You can just name a trustee. If you have a small family, that's what most people do, actually. Most people just name a trustee. But if you've got other people involved, you can name a trust protector. Our law firm and other law firms often serve in that role. The trust protector can amend the trust if there are any legal problems with it. If the special needs trust law changes and the trust no longer qualifies as a special needs trust, the trust protector can go in there and fix those provisions. You can name an investment advisor. You can say, our trustee is going to do everything except manage the investments of the trust, and we want this person or this company to do that. And you can name or require the trustee to choose a care manager. And a care manager is usually a social worker or a nurse who goes in and checks on the beneficiary to make sure their care is adequate to excellent, and reports back to the trustee so the trustee can make changes to improve the beneficiary's care. A care manager is absolutely necessary when you have a bank as a trustee. May not be as necessary when you have family members involved, or you may name the family members as the care manager. So you may have a professional trustee investing and managing the assets, and you name a brother or a sister as a care manager. If you've got more people than one, you can name an advisory panel. So that's kind of like a care manager, but more than one person. And you can name as many people as you want on that panel. Just keep it in your mind, once you get past 3 or 4, you're getting on towards the Roman Senate and lots of arguments. So, so an advisory panel is also another choice to make your trust really work for your beneficiary. Mistake number 8 is disinheriting your child and expecting their siblings to take care of them. This was really popular before special needs trusts came into existence. The parents would have 2 children, they would disinherit one, leave everything to the child without special needs, and tell that child, hey, you have a moral obligation to take care of your sibling. And sometimes they did, and sometimes they didn't. Some of the risks to that strategy are, what if the healthy child gets divorced and half of their inheritance gets taken away? Now they have much less to take care of your child with. What if they get sued and their inheritance is taken away by a plaintiff? What if they hit a school bus full of lawyers' kids and they lose everything? What if they go bankrupt? They'll lose the entire inheritance and they won't be able to care for your child. What if they die first and your special needs child outlives them? Who's going to take care of them? And what if they face financial pressures? What if they invest in something that goes bad? What if their spouse has a gambling problem? What if they start a business and it needs cash? It's very tempting to use their inheritance for their needs and assume or tell themselves that they will continue to be able to care for that special needs child, whether that's true or not. So relying on other children to provide for your special needs child is a very risky strategy. Very risky. And it makes your child dependent on their sibling, which can cause conflict depending on your child's level of competence. Mistake number 9 is failing to fund and maintain the plan. Your attorney should structure the plan so that the inheritance goes directly into the special needs trust and doesn't go through the child's name first or anyone else's name. You need to maintain your plan by checking with your attorney every few years, because special needs trust law does change. If you create a revocable living trust to avoid probate, You need to make sure that all of your assets, your house, your bank accounts, your investment accounts, are titled in the name of that trust. Because otherwise they'll go through probate, and that makes your child's address part of the public record, the will or trust part of the public record. It just puts them at risk of scammers and lots of advertising. Mistake number 10. What is the biggest enemy? Mistake number 10 is thinking it's probate or taxes. It's actually procrastination. There's financial procrastination. Oh, we don't want to pay for this yet. We'll pay for it when we get our bonus. There's time-based procrastination. I'm so busy at work. Things will lighten up around February. I'll do it then. There's fear-based procrastination. I've never worked with an attorney before. This is going to be so much work. It's burdensome. I don't know if I know the answers to the questions they're going to ask. I don't have anybody to name as trustee. That's a common one. Don't let that hold you back, because there are professional trustees who will take great care of your beneficiary. So come in and talk with an attorney and learn who those professional trustees are, so you can introduce yourself to them and find out how they work and get a level of comfort. And then there's the just one excuse after another. You know how that goes. It's never the right time. There's always something in your way. It's because it's something you don't want to do. So what I would suggest, if you're doing just one excuse after another, is really examine why you want to do this, so you can get motivated to overcome the reasons why you don't want to do it. You want to do it to take care of someone you love, and address the reasons you don't want to do it. You don't want to go into an attorney's office. Well, why? Is it because you're afraid it's going to be intimidating in a high-rise building with lots of glass? Maybe that's not the kind of attorney you want to choose. You want to choose an estate planning attorney that's not part of a big firm, that just does special needs and estate planning. Examine your other reasons for not wanting to do it. So at Braverman Law Group, we offer a free consultation to boost you over that procrastination hump. I'll put in the chat, let me see if I can do it. I'll put in the chat the email address for my assistant, Melanie, at braverman-law.com. Braverman spelled B-R-A-V-E-R-M-A-N. You can email her for a free consultation with me. And I'll also put in our phone number if you prefer to call to schedule your free consultation. Okay, I got all that in the chat. So there are 3 Ds. I got this from some kind of organizational guru. 3 Ds to overcome procrastination. Delegate it, dump it, and do it. So delegate it. We will do it. We will do it for you. We'll ask you some questions. We'll help you think about them. We'll walk you through them. And then we'll create a document. You'll review it, make any changes to it that you want, and sign it. So we'll do the heavy lifting. You just answer some questions and think about your choices. Dump it. Dump less worthy tasks to make room for this. You know there are things that are less important than creating a special needs trust for your child. Put those to the side for a little while. You can always come back to them. They'll still be there. And do it. Just like the Nike ad. Just call Melanie right now. Send her an email. Call whoever you want to. Just get it done. Just make the call and do it. Okay, guardianships we talked about. I'll just point out that guardianships are not needed until after the age of 18 because a parent has all those powers under the age of 18. Of course, if the parents are not taking care of the child, then a guardianship is needed. Like if the parents are deceased, then a guardianship is appropriate, but normally not until after 18. If your child needs to be protected from their own decisions and won't just go along with what you say, you may need a guardianship for your own child when they turn 18, because you may need to steer their decisions in directions that are not their first choice. Conservatorships likewise are only needed if the child is 18, unless they get a bunch of money under 18. So if a grandparent leaves a 13-year-old $1 million, the parents have to go get a conservatorship, unless it's left in trust. And then the conservatorship is the vehicle they use to invest and manage that money. If your child has money in their own name, my first question is, should we put it into a first party special needs trust so that it's protected and they can receive their government benefits? And then my second question is, if no, should we obtain a conservatorship so that you can control that money rather than having it at risk of scammers and anyone who may influence your child? These are all the slides I have prepared. I'd be happy to answer questions. And if you don't ask questions, I'm going to come up with some of the most common questions I hear. Okay, how much does it cost? That's a really common question. And it's going to depend on the law firm, but you can probably expect to pay for a third-party special needs trust. That is one that's created as part of an estate plan, $2,500 to $4,000, maybe less if it's part of a comprehensive estate plan. For a first-party trust, that's the kind where we have a hearing, we go into court, it gets approved by the Medicaid agency. It's much more demanding to set up a first-party trust. You're probably looking at $6,000 to $8,000, or rather your child would be looking at $6,000 to $8,000 if you didn't set it up for them. If you create a special needs trust as part of a living trust plan, you're probably looking at around $5,000 to $6,500, depending on whether you're an individual or a couple and whether you need any tax planning. So those are some ballpark figures. Of course, every firm is different. So if it's higher, if it's much lower, I'd be a little suspicious. Why is it so much lower? And if it's much higher, I would assume that's because it's an exclusive firm and they have a lot of overhead and you're paying for that. Let's see, what other questions do I get? Who can be named as trustee? You can name anyone you choose who's over 18. So you can name a sister, brother, aunt, uncle. There are banks that will serve as trustee, and they typically charge 1% of the assets per year. There are fiduciary services that will serve as trustee. They can charge either a percentage of the assets or an hourly rate, maybe $150 an hour, to serve as trustee. None of those fees will begin until after you are gone and the money goes into the special needs trust for your child, assuming we're talking about an estate plan. If the money is going in right now because it's a personal injury settlement, then of course the trustee is going to start to work right now. The trust protector often has the power to remove and replace trustees if they're misbehaving or overcharging. You can also give the power to other people besides the trust protector. You could give a sibling the power to remove and appoint a new trustee, so that while the sibling isn't the trustee, they do have the power to supervise the trustee. Let's see. A memorandum. Go ahead, Margie.
So there's a couple of things here. What are some questions to ask of a lawyer to determine if they understand how to create a special needs trust?
Okay. Okay, questions. Yeah, go ahead. What's the other one?
Another one about having a backup trustee.
Yes, okay. Anything specific about that, or just choosing one?
No, just pretty open-ended.
Okay. Okay, great. So questions to ask a lawyer. I would ask them how long they've been drafting special needs trusts. I would ask them how many special needs trusts they've made. You want it to be, I would say, at least 5 years. They've been drafting for at least 5 years, and they've made at least 25 to 50 special needs trusts. You don't want to be their practice trust. You want to ask them if special needs trust is a substantial part of their practice. Do they create special needs trusts once a year, or do they create them every week? Let's see. A good question, kind of a sneaky question, is to ask them if they've ever gone to court and established a first party special needs trust, even though you don't need that. And the reason it's a good question and a little sneaky is it shows you just how comprehensive their special needs planning experience is. It shows you, do they really handle special needs trusts A to Z, or are they only doing estate planning special needs trusts, which is not the same level of knowledge, legal knowledge about special needs planning. So you would ask them, have you ever established a court appointed first party or D4A trust? And you would want them to say yes, and that they've done a few of them. They don't have to do a lot. They're not terribly common, but just a few. Let me answer your question about a backup trustee. You absolutely want a backup trustee unless your first trustee named is immortal. And what do I mean by immortal? I mean like a bank or a trust company, where if the trust officer handling the trust retires, there's someone else behind them to take their place. And in 40 years, there will be another person behind them to take their place. So if you name a trust company or a bank as the trustee, you don't need to name a backup. If you name a person, especially a person older than your special needs trust beneficiary, but even if it's a young person, you have to name a backup trustee. You really just have to, because if you don't, what's going to happen is the court is going to name a backup trustee for you. And once the court has named a trustee, the court may take jurisdiction over the trust, meaning that the court may require the trust to report every year. The court may require a hearing every year, and that's just going to really drive up the costs of administering the trust and drive down the amount of money that's left for the special needs trust beneficiary. So that's the consequences of not naming a backup trustee. When people name individuals, I usually recommend they name two backup trustees. 3 is good, 4 is fine, but at least 2. And then maybe consider naming a bank or a professional fiduciary at the end of the list, just so that if the worst case scenario happens and all of your backup trustees are gone, it doesn't have to go to court. It goes to that bank or professional fiduciary. That way you avoid that extra expense and publicity. Because again, that's a public court proceeding. So anyone who wants to can find out how vulnerable your beneficiary is and possibly how much money they have and who they need to talk to get at that money. So backup trustees are critical. Some financial planners will serve as trustees, but it's not something I usually recommend because that's just not their area of expertise. CPAs will serve as trustees. They can be great co-trustees because they can keep track of all the money, but they tend to be very conservative with investments, maybe too conservative, and they may not be as interested in the soft side of caring for your beneficiary as a family member or a professional fiduciary or a care manager. So you can name professionals as trustees. Most lawyers will not serve as trustee of your special needs trust. It's just not what we do. Our compensation structures aren't set up for that. Our days aren't set up to take calls from beneficiaries whenever they're needed. So I would be concerned if the lawyer wants to be the trustee. We do have a family asset protection survival guide that we can send out to anybody who's interested in it. It's a free guide. And it has a lot, it's mostly about revocable living trusts and other kinds of asset protection, but it does have a couple of articles on special needs planning. It's a lengthy PDF. It's 70 or something pages. So you may have to go through some pages to get to the special needs articles, but there is a table of contents, so you know where you're going. If you want to get a copy of our family asset protection survival guide, you can just call it our guide or our family guide. You can email Melanie. It's in the chat, melanie@braverman-law.com, or call her. That's in the chat, and give her your email address and she'll send it out to you. So that'll give you some text if you want to share an article with someone who wasn't here or just review some of the things we've talked about. Let me see, what else do people want to know? If you have a beneficiary who's receiving Social Security disability income, SSDI, that's very different from SSI, Supplemental Security Income. You'll know because Social Security disability income comes with Medicare. So if your beneficiary has Medicare and gets a check from Social Security, they're probably receiving SSDI. SSDI is not a needs-based government benefit. It's what's called an entitlement. So you don't have to have special needs provisions for a person who's receiving SSDI and Medicare unless they are also receiving SSI or Medicaid. SSI and Medicaid are needs-based, and anything over $2,000 will cause them to lose those essential benefits. So some people have both. It's called Medi-Medi. You may have heard your child has Medi-Medi. That means they have Medicare and Medicaid. In that case, the special needs trust is appropriate. But if they only have SSDI and Medicare, I would look into whether they're eligible for Medi-Medi, because that would pay more of their expenses. But if they're not, then a special needs trust can be a helpful tool for managing their assets, because it has all those different parties fitting in like puzzle pieces to create a comprehensive structure to support your beneficiary. But it's not necessary to preserve the SSDI or Medicare. I think with that, I will turn it over to Margie to close up our session, and I'll answer any last questions.
Great. Thank you. Let's see if we can get our screen share here.
Oh, do I need to stop screen sharing?
Yeah.
Stop. Okay. There we go.
Okay. And yeah. Let me see if I can pull this up. Great. Okay. Well, thank you all for participating today. And after our session here, feel free to email if you have any questions that come up. You can email Melanie at Braverman Law directly, or contact us at Senior Law Day at info@bocoseniorlawday.org. I can put that in the chat as well. Diedre, wonderful presentation, a lot of information there. It's just amazing how complicated things can get for a child with special needs, or a person with special needs, and being able to make sure that they're cared for and will be managed, have their care managed properly for the rest of their lives. So that's really important work. All right. Well, I don't see any more questions right now. So I think we'll just sign off, say goodbye, and hopefully we'll see some of you next week.
Great. Thank you all for attending. And feel free, if you have questions for me, email Melanie. She'll get them to me. I'll get back to you.